Due to the amount of material that we will be covering in this video, we are posting technical assistance guidance on the Facebook page and on the YouTube channel. This technical assistance guidance includes a definition of terms that you will hear in the video, along with a link to different information and documents that you will need as you advocate for yourself and/or for your loved one. In this video, you will hear Kyle talk about things like Medicaid Provider Manual and Medicaid Fair Hearing Request Form. We will make sure that you have the information that you need. You will see some of the terms inserted into the video, but all the information will be accessible through the links posted on the Facebook and YouTube. You can also reach out to Marianne Huff via email at mhuffmham@gmail.com for more information.
My name is Marianne Huff. I'm the director of the Mental Health Association in Michigan. And what we're going to be talking about today is the Medicaid Fair Hearing and Appeal process and how to navigate that. Part of what we're working on, the Mental Health Association in Michigan, which is an advocacy organization for individuals, adults, and kids who have psychiatric conditions, is educating individuals about how to exercise their rights and how to be good advocates for themselves and those whom they love, particularly within the public mental health system. So what we're hoping today will be for you is an educational opportunity, and one which will help you to be able to let your voice be heard, particularly if you are someone or someone you love is receiving services from a community mental health services provider or a CMH, or a Pre-Paid Inpatient Health Plan or a PIHP, or if someone you love is receiving services from a MICHOICE Waiver agent like the Area Agency on Aging. Our focus is on your rights to ask for an appeal and a Medicaid hearing when your Medicaid covered service is changed in some way by the CMH, the PIHP, or by the MICHOICE Waiver agent. We're also going to talk about your right to challenge that decision made by the CMH or the MICHOICE Waiver agent. And we want to let you know that this is available to you whenever you are getting Medicaid-covered behavioral health or support services from a CMH or a MICHOICE Waiver. One thing I do want to make sure that I say as a disclaimer is that this is obviously not a substitute for legal advice. And also, this webinar does not deal with non-Medicaid appeals for individuals in the community mental health system, and it does not deal with Medicaid appeals for health plans that provide physical health care. I also want to recognize our partner organization, Michigan Protection and Advocacy Service. We are really pleased to have the Director of Litigation Services with us. His name is Kyle Williams. So I want to now formally introduce Kyle. And Kyle is our expert for the day. He is the director, as I said earlier, of litigation strategies at Michigan Protection and Advocacy Service. He's very, very involved in a lot of aspects of his organization. I'm going to let Kyle tell you a little bit about himself and what he does. Kyle?
Sure. Thank you, Marianne, and thank you for having me today, and thanks everybody for coming. My name is Kyle Williams. I'm the director of litigation over at Michigan Protection and Advocacy. I started working for a private law firm about 10 years ago, and I've been a prosecutor. I have done municipal defense for a city in Michigan, and I spent the majority of my career representing people with disabilities as a staff attorney and now as the director of litigation here at Michigan Protection and Advocacy. With regard to Medicaid fair hearings, I would estimate that I've represented about 100 people in my career doing Medicaid fair hearings as a part of their case or the primary reason for the case. Been working through this system over the course of a number of years. My hope is that I can, try to simplify the system as best as I can and help you all learn from the mistakes that I have made and representing people here, and hopefully give you some good advice that you can avoid making those mistakes yourself.
We want to thank you for taking time out of your busy day to spend a couple of hours with us talking about one of the advocacy tools that folks can use when they receive those Medicaid covered services from a CMH or a MICHOICE waiver. What I'm wondering is, when you think about the Medicaid fair hearing process and how a person gets to that place, think one of the very first questions would be, what do you need to be thinking about before you even get to that place of preparing for a Medicaid Fair Hearing? So like, in other words, what do you need to do ahead of time to make sure you have the best chance of getting a service, keeping a service, or preventing services changes that you don't want from happening?
Yeah, and I think that's a really good place to start, that oftentimes we only pick up the cases whenever it's ready to have a hearing, but there's actually a lot that you can do as a person who receives benefits from community mental health or MICHOICE Waiver or Medicaid Waiver, things that you could be doing before the hearing that can either resolve the need to have the hearing in the first place or have you in a better position if you do in fact have to go in front of a judge and present your case, so that you can, in a sense, get your ducks in a row before you even start engaging in this process. All of this starts at your individual plan of service. So depending on who you're served by, they may call this document something different. We typically refer to them as an IPOS or an individual plan of service, but it could just be a plan of service. Ultimately, it is a document that's going to define what your goals are and what services you're going to need in order to achieve those goals. So for anybody who receives these types of services, you're probably used to having at least an annual meeting where you discuss this document and make changes to this document and talk about your progress and reaching those goals that you've identified and work with typically a supports coordinator or a case manager and developing. The first place to start is making sure that you have the correct and the best goals that you can have in that document. And the way that you get those goals is by having an IPOS meeting. So either doing that annually or asking for an emergency meeting or asking for a meeting whenever it can be scheduled at its earliest convenience, where you can get together with your supports coordinator and you can talk about what your goals are. So some of the goals that we typically talk about are goals like living independently. So for folks who are living with their parents and are ready to transition and go and live on their own or live with roommates, that is a goal that you may need services in order to achieve. And so that is something that would be appropriate to have that plan of service tailored to help you reach that goal. You may have a goal that you want to get a job or you want to volunteer. You may need services in order to achieve that goal. And so starting with the goal is really the first place to start with these documents. And once you have your goals laid out and you've been able to consult with whoever is actually receiving the services, plus their friends and family, and you can have a set goal that you can try to reach. And then at that point, you can kind of move on into what services you're going to need in order to achieve those goals. Once you have your goals all worked out and you know what you're trying to accomplish, then you're going to reach the point where you need to determine what's on the menu. And so whenever I say the menu, I'm talking about what are the covered services that are available to you in order to help you achieve the goal. And ultimately, you can't just have anything that you want that could possibly exist. Whenever you're working with Medicaid, they're going to have a list of covered services, and you're going to be entitled to those services as a Medicaid recipient if those services are medically necessary in order to meet your goals. We'll talk a little bit about medical necessity in a second, but ultimately, once you have those goals and those goals are good and it's what you want to try and achieve, then you're going to shift the focus of that IPOS meeting to what services you're going to be able to get in order to try and achieve those goals. As a basic core concept, the way that Medicaid should work is that you should be entitled to all covered services that are medically necessary to help you achieve your goals. Knowing what those covered services and knowing the extent of what those are is extremely important in trying to figure out what you need in order to meet those goals. That we have a lot of clients that run into an issue where they go in, they have these meetings, and then they are told what they can have and what's available. And then it's up to them to either take it or leave it. It's important for folks to know that there's a list of covered services. There's a menu that you can choose from, and all those should be made available if you can prove that those are medically necessary. So shifting these IPOS meetings away from here's what available and here's what you can have to here's what I need and here's why I need it, as long as it's a covered service, focusing in on what you need and making those requests rather than relying on the CMH to tell you what you need is a really important thing that you can do before the hearing in order to make sure that they know what you need, they know why you need it, and you can point to the Medicaid provider manual or whatever you would be saying to as far as why those services are actually going to be covered. You always want to talk about this stuff in the context of medical necessity, and we'll be coming back to medical necessity pretty much throughout this conversation that we're having. So it might be a good point now just to kind of lay out what is medical necessity and talk about how you're going to argue whether or not services are going to be medically necessary or not. I think Marianne will put a link to the Medicaid provider manual that our state publishes and puts out to the public, which kind of lays out what, are the covered services, what's the criteria for getting those services. And this is what's primarily going to be used in any administrative hearing to make a determination of whether or not you're actually going to get these services. And so I'm sure we can post a link, but if you go to it, it's like a 3,000-page document. It is tremendously long. I just want to point you to one specific page. It's page 334. And this is going to be the Medicaid mental health and developmental disability supports and services medical necessity criteria. And this will be important to just think about throughout this process, whether you're at the local appeal, whether you're at the fair hearing, whether you're just talking about these services in an IPOS meeting. This is the criteria that these services will be run through to make a determination of whether or not this is something that you need. So just covering them briefly, you're going to get services that you need that are necessary to screen you or to assess you for what your needs would be according to whatever the symptomology would be of a mental illness or developmental disability. And mind you that all of this is being kind of written through the medical context. So, I'm not a doctor, but this is a medical determination. And in addition to that, and what's really important whenever it comes down to the actual service provision is whether or not the service is intended to treat, ameliorate, diminish, or stabilize those symptoms of a mental illness or a developmental disability. In addition to that, if you have a service that would be expected to delay the progression of a mental illness or a developmental disability, that would meet medical necessity criteria. And the final criteria, and the one that I think is the most important and the one that I frequently cite and rely on probably the most in any of my representation, is services or supports that are designed to assist you to maintain a sufficient level of functioning in order to achieve your goals of community inclusion and participation, independence, recovery, or productivity. That is an awfully broad category, and there is so much that can fit within that category. Because I think that the one mistake that I made getting into this is that I thought of medical necessity as, if I don't get this, then I'm going to die or I'm going to be seriously injured. And with the context of community mental health services, the services are not medically necessary because you will die without them, or they're not medically necessary because you're going to be severely injured if you don't get them. You get them if you can meet those goals. You can participate in your community and live in your community and be in the least restrictive setting. You may not die if you don't get to get transportation services to go to your volunteer work that you have. And you may not die if you have to live with your parents as opposed to living independently. But the goal for these services is community inclusion, being served in the least restrictive setting. And so that is the context by which we are going to analyze whether or not you need this service. It's not going to be whether or not you're going to die without them. It's going to be what you need in order to reach those goals that are in your IPOS and make sure that you can be a part of your community. Thinking about that even from the beginning, before you even get involved in hearings, whenever you're communicating what your needs are and what you're communicating what you need tailored to those goals, that's the criteria. And so it's important, even from an introductory or a pre-hearing stage, to think about these services within the context of medical necessity so that you can talk to your supports coordinator and talk to your CMH and know what the criteria is for whenever you do not get services, and be able to make those arguments on the front end and provide them with the information that they need in order to make that determination, whether it's a letter from your doctor, maybe a letter from grandma who sees you on the weekend and can talk about kind of what your needs are whenever she's providing some respite for you, or whoever it could be, friends, family, treating providers. If they have comments or thoughts on what you need based off of their experience, if you yourself as a beneficiary have comments or thoughts on what you need in order to achieve those goals, having all of that up front is extremely important and can sometimes resolve your issue without the need to even have a hearing on that in the first place. Whenever you're talking about doing that and showing that, having letters from your doctor, having letters from your providers to detail what you need. If you need 24/7 services, you can have a doctor explain why you need that. And then you have a medical determination that you can show the CMH supports what you're asking for, or supports why they shouldn't be taking away something that you previously received. So all of that is helpful. It's all helpful to have on the front end so that they have as much information as possible that's favorable to you whenever they go through their utilization management process and try to come to a determination of what it is that you need. Get them as much as you possibly can on the front end. And that's really the best that you can do to either avoid this process or to set yourself up so that you're going to be at the greatest likelihood of being successful at these hearings, because you're going to be making the same argument throughout this process because you were prepared from day one. You went to that IPOS meeting and you had everything that you needed to support your argument, and then you're just doing the same thing throughout the process. You know, just having your ducks in a row and thinking about this through the context of what is medically necessary, what isn't, and knowing what those covered services are that are available to you so that you can make those specific requests if they aren't made available to you through that IPOS meeting.
So Kyle, first question is, where would someone find out more information about services that are covered that they can get as a Medicaid beneficiary?
Sure, and what you're going to want to look to, and we'll provide you with a site to this, is the Medicaid Provider Manual. So I cited you that page 334 for where the medical necessity criteria is, but you're going to want to look to specifically how you receive your services. Most people at a CMH are going to be receiving their services either what is under the Habilitation and Supports Waiver, which is a Medicaid waiver that for people who are required to be in what's called intermediate care facilities can be served in the community. And so it gives additional supports and services for folks so they do not have to be in that institutional setting and can live in their community. And there's also a waiver called the B3 waiver, or sometimes it's called the I waiver, which is just additional supports and services what Medicaid would generally cover, which will have the purpose of making you more independent, more included in your community, and being able to be served in the least restrictive setting. So if you just look at that site, you will be within the correct chapter. And then all you have to do is go to the table of contents and then ask your support coordinator, do I get served by the HAV waiver? Or how do I get served? Am I served on the B3 waiver? And once you know how you're served, you can go and look at those specific sections of that chapter, and there should be a whole section of what's covered under it. And then knowing what is covered is going to be a great starting point for you to go into an IPOS meeting to talk about what you need and what's available to you, as opposed to not knowing what's available to you and then being told what you can have and what you can't have.
Okay, thank you for that, Kyle, because I think a lot of times folks are confused or not sure about what services are actually available to them, you know. So any more thoughts about how folks can prepare to, in a way, what we're talking about is protect their services or get other services that they might need if they're getting served through community mental health, right?
So typically you're going to run into one of 2 or 3 situations whenever you're thinking about doing an appeal or being subject to a situation where you need to do an appeal. And that's going to be either a termination of your services, so they're taking your services completely away. You used to receive 50 hours of community living supports, now you receive 0. A reduction of services, so you used to receive 50 hours of community living supports, now you only receive 20. A suspension of services, so everybody agrees what you need, but for whatever reason they're unable to provide it. That's an appealable issue, and you can go in front of a judge for that. And then lastly, a denial of services. If you are being told you can only have these certain items and you request additional items or services or supports, then you can make that request and they will be required to either give it to you or deny it, or give you something in between what you're asking for and a denial. And then that will be appealable as well. And so it can really come up in the context of any of those 4 situations, plus some additional ones that I'll mention a little bit later. But that's generally speaking whenever you're going to start having to think about exercising your due process rights and moving forward with an appeal.
So Kyle, you just brought up a really important concept. People hear about due process, and I think a lot of folks wonder, why do we even have this right to appeal a decision or a determination by a CMH or the MICHOICE Waiver agent? Can you just kind of talk a little bit about where due process comes from and why it's important?
Sure, and I think that the first thing I'll mention is that we could probably talk for the rest of the day about due process and what it is and how it's been developed through case law over the course of many decades. But just as a general, very simplified explanation of what due process is, you'll find due process in the Constitution of the United States of America. It's found in the Fifth Amendment and it's found in the 14th Amendment. And the Fifth Amendment isn't very relevant to our conversation. I think most people know the Fifth Amendment from whenever you don't want to say something that might be incriminating to you, not something that's applicable to this situation. But the 14th Amendment certainly is. And what the 14th Amendment says is that the state, and really it's the state and federal government, will not deprive any person of life, liberty, or property without due process of law. So that's really all it is. That's the law, that's all it says. And what that has actually turned into is a result of courts interpreting what that means. So the best way to think about due process is that it's a sliding scale, and you get more due process whenever the government wants to take more from you. So probably the classic example of the most highest level of due process is going to be the government wants to put you in jail because you committed a crime. If you commit a crime, you are allowed to have an attorney. If you cannot afford one, one is appointed for you. The government has to prove its case by beyond a reasonable doubt in order to take away your life, essentially, by placing you in jail. The same concept can be applied to, say, a guardianship hearing. You have a right to an attorney at that hearing. The petitioner will have to prove their case by a preponderance of the evidence. However, you do not have a right to beyond the reasonable doubt standard on that. So the due process for a guardianship hearing gets a little bit less because the right is not as substantial as placing somebody in jail. And then if you continue down the line, you're going to reach your Medicaid hearing. And the reason why you get due process rights for your Medicaid hearing is because Medicaid is what's called an entitlement. So you actually have a property interest in your Medicaid benefits. And so if the state wants to take those away from you or change those benefits, then they're required to give you due process of law. And what due process of law looks like in a Medicaid Fair Hearing context is you have a right to a hearing in front of a judge who's going to be impartial and be able to make a decision based off the evidence that you're going to be able to present. So you have that right to present evidence, you have a right to call witnesses, you have a right to cross-examine witnesses that the department or the agency who's taking the action against you will bring. And you have a right to object to evidence that comes in that you don't think is appropriate or relevant or otherwise needed in the hearing. So that's what your due process rights look like as a general matter. That's where your rights come from. And really, this is something that, again, we could talk about for a very long time, but that's what it is boiled down for you. And probably one of the more important due process rights with regard to these types of services is your right to continuing benefit. So if the community mental health or the area agency on aging, if you're on the MICHOICE Waiver, decides to take something away from you, so you're either having your services reduced or they're being terminated, you have a right to receive those benefits pending your hearing, but you must do your request within 10 days of that action. So they're going to be required to tell you in writing what action they're taking and why they're taking it. And if you dispute that by filing your local appeal or whatever appeal you would have available in that instance, within those 10 days, and it's a Medicaid service, you're going to be able to continue to receive those services up until that hearing. And then if the decision is in your favor, those services will obviously continue. And then if the judge decides against you, they will then be able to take away those services. One thing to note is that the state does have an available remedy to recoup the cost for those services. I can certainly say I've never seen that happen. I don't know that there's a large practice of doing that through community mental health or the area agency on aging in our state, but it is out there and it's something to be considerate of exercising that right. But you certainly have a right to continuing benefits if you can get an appeal out within 10 days of those adverse benefit decisions. And ideally, you can do that within the authorization period that those services have been approved for.
Kyle, can you talk a little bit about the appeal? And isn't it now that before someone, if a service is changed in some way or denied, don't they have to go to an appeal first before they can request a hearing from the state?
They have added some layers to these particular types of appeals. These appeals with community mental health services for Medicaid beneficiaries, as well as the MICHOICE Waiver, where essentially there's an added layer to this now. It used to be that if you disputed the decision that was made, you could go directly in front of a judge, have it addressed, and then get a decision. Now they have added what's called a local appeal to the process. This is essentially a second layer that you have to go through. You must exhaust this process before you can get in front of a judge. But basically, you're going to go in front of a local appeal officer or somebody at the agency or entity that took the action against you. And then you're going to be able to present information. You can do these either in person or by writing. You can call and do this orally to dispute. You can submit it in writing. You can make factual and legal arguments. But ultimately, the CMH gets essentially 2 cracks at it. That they get to make a decision. If you dispute it, it gets reviewed by the CMH. And then they're going to either reverse the decision or uphold the decision. And at that point, if they uphold the decision, that is when your right to actually go and do the Medicaid Fair Hearing will be created. So it is a process that you have to exhaust. You do have 60 days to actually exhaust this process. So from the date that you get that written notice, or if they take an action against you and they didn't provide you with written notice, you've got 60 days in order to appeal that and do that local appeal. And that local appeal will be done, it will have a written decision that will be sent to you. You will get that within 30 days, whenever you file that local appeal. And then that written decision should advise you on how to file a fair hearing.
For community mental health, do you know, like, who would someone contact to request that appeal?
Well, every community health is different. So the first person that's best to talk to is your supports coordinator, because they're usually the one that's going to be telling you you're either getting this or you're not getting this. They're going to tell you what you are and are not getting. And so you can either make the request through them or ask them to identify who. They're typically called a local appeal officer, a hearings coordinator. There's a couple of different names for them. But since it's different in every single county, the best thing to do is ask your supports coordinator, tell them that you disagree with either the services that are authorized or the decisions that were made with regard to your decision, and they can either point you in the right direction, or they can just take that complaint directly and give it over to the local appeal office to get it started for you.
Okay, great. So the person gets a denial, they submit the appeal to the office, probably, the CMH or the PIHP, and then they get told that it's denied. What process does that start then?
So assuming that you are unsuccessful on your local appeal, then you're going to move on to your state fair hearing. And before talking about the state fair hearing, I do want to note that the local appeal does have the added benefit that it requires them to answer your complaint or your appeal with a written response. So that's going to be probably the best point in time where you're going to really know what the CMH's reasoning is. Oftentimes the notices that you will receive that communicate what's happening to your benefits don't really provide a lot of detail on the reasons why. Some of them do a pretty good job of detailing what exactly is happening, but oftentimes they don't really provide a really robust reason as far as why they're taking the action. So the local appeal has the added benefit that you can have a better understanding of what their position is, so that you can better address their argument whenever you get to the second stage of the Medicaid Fair Hearing. But after you complete that local appeal hearing and you have that decision on your either request for services or your dispute over taking away services from you, you're just going to file what's called a fair hearing request. So this is MDHHS form 5617-MAHS. And we've got this attached to some of the documents that we're going to circulate after this as an exhibit to some technical assistance documents on doing these hearings. But essentially, it's as simple as signing a form saying that you want a fair hearing, saying that you contest the decision that has been made by the agency or the entity that took that adverse action against you, and letting them know that you'd like a hearing in front of a judge to address your dispute with that decision that was made against you. So some particular tips in doing this: you can do this as a beneficiary, or you can designate what's called an authorized hearing representative to assist you in this process. So the form allows for you to elect to have somebody assist you. This person does not need to be an attorney. It can be your friend, it can be a family member, it can be somebody who's familiar with your services. Does not need to be an attorney. The only requirement for that authorized hearing representative is that they're going to be of sound mind and that they're going to be over 18 years old. So you can't have your 15-year-old sister come and represent you at the hearing. You need to have somebody over 18. And you're going to need to sign that, or your guardian's going to need to sign that. If you are in a situation where you are under guardianship and you wish to contest a decision that was made against you for your community-based services, your guardian can sign and represent you at those Medicaid Fair hearings. However, it is important to communicate to the court proof that you are guardian. So whenever you're submitting that hearing request, it's always nice to attach a letters of guardianship or an order appointing you as guardian so that the court knows, okay, this person can sign on this person's behalf. I can accept this appeal. So just giving them the proof that you are in fact a guardian and doing that along with the request will help you try to, you won't have to resolve that issue later because ultimately the court needs to know that you are somebody that can in fact sign that and take that action on that person's behalf, which the guardianship should grant you as long as it's covering your legal rights.
So what you're saying is for this process, you don't have to have an attorney. It can be a friend or a family member or somebody that you trust can help you with this, or you can represent yourself too.
That's right. So you have, any of those options available to you. If you wish to go out and get an attorney and an attorney can represent you, you can certainly have an attorney represent you at these hearings. It's just not necessary.
Okay. So to the average Joe or Joanne, this process sounds really scary and complicated. Is there any advice or recommendations you can make to folks so that they can think about how do we prepare for something like this? Because they hear that they have to go before a judge, that can become very overwhelming.
Yeah, and I think that the best thing that you can do is just understand what's going to happen. And then if you understand what's going to happen, you can better prepare for that. So before I get into that, I do want to mention that you have 120 days from the date that you get notice of whatever that adverse action is to file this fair hearing. So thinking about that within the context of you have to exhaust this local appeal requirement, you have 60 days to exhaust the local appeal. If you wait until that 60th day, you appeal it, you get 30 days to get your answer, you're at day 90. So you got to put some giddy up in getting the state hearing or the state fair hearing out because you only have 30 days at that point. So always be conscious of what your timelines are, because the worst thing that can happen to you is you file that appeal on the 122nd day, and then it gets kicked, and they don't even consider whether or not the decision was right or not because you missed your deadline. So always keeping appraised that your deadlines is important throughout this process. What you should expect after you file that request for a hearing is you will get notice from the court that will set that matter for a hearing. And you have a couple of options on what type of hearing you can have. You can have a hearing that is either in person, or you can have a hearing that is over the telephone. These hearings will automatically default to being a telephone hearing unless you make a specific request for an in-person hearing. So you can do that in the request to say, I would like an in-person hearing. If you have an in-person hearing, the judge will be in the same room as you, the CMH will be in the same room as you, or the AAA if you're a MICHOICE Waiver recipient. All of those folks will be in the same room. I can talk to you a little bit about when you may or may not want to do that, but ultimately you have that right. It's your decision of whether or not you want to have that in person or over the telephone. Right now with COVID, they are not scheduling in-person hearings. So you simply cannot get them right now. So you have to do a telephone hearing. But once we get COVID resolved and we're back to more of a more normal process, we'll continue to have that right to an in-person hearing. Before you get to that, you'll get a notice that's going to tell you the date and the time. It's going to tell you where to show up if you're supposed to go in person. And it's going to, generally advise you of when you're going to have your hearing. And some important rights that people might not know about is that if they give you that date and time, they don't consult with you about when they're going to do that. And sometimes that time doesn't work for either the beneficiary, you're out of town, you got to work, something's going on, you can't make it there. You can submit a written request to have that date adjourned. And so it can be moved to a later date if for whatever reason you're unable to make it. And the best way to go about doing that would just be to submit request in writing. Whenever you get that notice at the top left-hand corner, you're going to see a docket number and a case number. So if you want to just cite that docket number and case number and the name of the individual, that's enough for the court to know what case it's going to be associated with. And then you can submit that over to the judge, and then the judge has the discretion to move that hearing date to a time where you're going to actually be able to participate in it. In addition to that, accommodations. If you need a sign language interpreter or any other type of accommodation to either have the in-person hearing or to do it telephonically, You can actually do that on the request form. It does have a spot to identify any needs that you may have with regard to an accommodation under the Americans with Disability Act. But you can really request an accommodation at any time. As part of the technical assistance documents, we did include a form which is used to request accommodations. But the easiest way to do it is just to do it on that request for a hearing. There's a spot for it. So if you have any needs like that, you can do that with the request and make sure that the court will accommodate you. And I do want to mention just briefly the in-person versus telephone hearing and kind of some considerations to make and whenever you're making that decision. And again, you can't have an in-person hearing right now, so this isn't really relevant to right now, but after COVID, you will have this opportunity. So I've had experience with doing both, and what I typically will, whenever I'm doing an assessment of whether or not I want to have it in person or over the telephone, I try to think about what benefits there would be to having the person there in person. So I can think back to, I represented somebody who had very severe swelling in his legs where he needed to have active massage, they needed to be lifted up. You could really see, the swelling, you could see the pain it caused, and you could see kind of the active intervention through, a 2-hour hearing. That I had a client that really didn't participate. His guardian and his mother was primarily the one that was doing all the argument and participation in the hearing. But he was there, and the judge saw him, and the judge saw the active care that was going on. So whenever we were in that hearing talking about, hey, this guy needs 24/7 care, or else he's going to have a bad situation, the judge was actually able to see that. He saw the care that was going on in the hearing. And we were able to be successful with that, I think, in part because the judge could actually see what that care looked like. In addition to that, whenever you're talking about assistive technology or durable medical equipment, I can think back to representing folks on trying to get wheelchairs, power chairs, or specific types of chair. Whenever you're talking about things like a tilt or recline function on the chair, you can actually bring the person in and show them the chair that they have, show them what the capabilities of the chair are, and then the judge can actually see that, and they can benefit from seeing, okay, this is what this guy's situation is right now with this chair. What they're asking for makes sense because I can see it. And so there are certain cases, there are certain services, there are certain clients that have that benefit that if the judge can see, either that equipment or see kind of the active care that is involved just in their daily life, you might be able to have a benefit from being in person. But that's not necessarily the case for everybody. And admittedly, those telephone hearings are a lot easier to work in your schedule. You don't have to travel, and you can do them from home. So there are added benefits to doing these hearings telephonically.
Kyle, there is a question. Is the state office, if someone wants a in-person, obviously that's not happening right now, are they doing anything through a platform like Zoom for a hearing, or are they just doing everything telephonically right now?
My understanding is that the administrative hearing system does not do video conferencing. They solely do telephone. And again, that's my understanding. I do not know whether they're working on getting that capability to do video conferencing. If you look at the most recent executive order, which is 2020-154, that's the order on suspending in-person hearings in courts. And I think specifically subsection 5 of that addresses administrative hearings. And what it says is that a judge may conduct that hearing over the telephone or by video conference. So really, there's nothing that forces the judges that I know of to do a video conference, but you can certainly make that request. And if the judge can accommodate that, then making the request is really the first step to that. But I'm unaware of whether or not they have that capability, and I'm told that they do not do video conferencing for these hearings.
So they go ahead and they request the hearing, and it's on the books, and they have to get ready for it. What are some tips about getting ready for the actual hearing itself that you can provide?
Yeah, and that's the great part about taking those prep steps before you're even going through the process, because you've already begun preparing for those hearings whenever you go into those individual plan of service meetings and you talk to your supports coordinator, because at that point, you know what the covered services are, you know what the medical necessity criteria is, you have an IPOS that has all the goals that you want to achieve and that you need in order to reach, whatever goals you have individually in your life. And so you're very well prepared at this point to move through this process because you did that work on the front end. You had those IPOS meetings and you got that document. looking like it needs to look like. It has the goals that are reflective of what you want, and you know what services you should be entitled to or that are covered under the Medicaid program. You've already made those arguments to the CMH, which obviously they disagree with, but you've made the arguments that those services are needed and are medically necessary to reach those goals. So that's really the benefit of doing all that prep work, because you start preparing for that hearing from the get-go. So really, your argument shouldn't change that much. It certainly can, and if it does, then, if it needs to change for whatever reason, you can do that. You have already gotten, if you're doing this prep work right before the hearing, you've already gotten to the agency everything that they would need in order to find in your favor and get you the services that you need. So it's really just a matter of looking back at that, making sure that all of that makes sense, making sure that you have, all of the evidence that you could get. Maybe you can go and talk to additional doctors, maybe you can talk to additional providers to get additional support for that. But ultimately, whenever you work and prepare those IPOS meetings in that way, then you've already begun preparing for the hearing. So you're able to submit evidence to the court before the hearing. It's important to do that at least 7 days before the hearing, because there are rules that kind of govern when you're supposed to be getting evidence into the court. I found that they're relatively relaxed about that. So if you move past 7 days, I would encourage you to try to get that information in either way. And the worst thing that could happen is that the judge will say, no, you can't get it in. So thinking about what additional information you may have, submitting that information that you've already provided to the CMH, because you don't want to rely on the CMH to bring forward all the evidence that supports your need for the services. That's your job. You're the one that needs to argue that you need the services, because the CMH is going to argue that you don't need the services. They already took that action. So all those doctors' letters, all those letters from family members or friends or providers that are supportive of what you need, you want to get all that into the court so that the judge can take that into consideration whenever they're at the hearing and whenever they're reviewing all the documentation and coming to their decision. And you also want to make sure that the CMH has it before. So whenever you're sending something to the court, you want to send it over to the CMH. So you want both of those entities to have all the information that you're going to need in order to make your case at that hearing, and to know that you can bring witnesses to those hearings. So think about the people that could testify at the hearing and talk about why this person needs this service, whether it's a provider, whether it's a family member, whether it's a friend, whether it's you as the guardian to make a statement, whether it's the beneficiary. Think about the people who can be supportive of what you're trying to get and who can talk about what actually is going on in this person's life. If you need 24/7 service, you're going to want to bring people to talk about what goes on in that 24/7 service. What portion of that is going to be just supervisory? What portion of that is going to be active care? What does that active care look like? You're going to want to prepare to show the judge what a 24-hour day looks like for somebody and what those care providers are doing during that 24-hour day. And ideally, you're going to have those care providers come in and they're going to tell the judge, because you're going to call them as a witness. They're going to get up and describe what 24 hours of this person's life looks like based off of the care that they have provided up until that point. And if you don't have it, you can talk about the problems that occur whenever you don't have what the services that you have. Say you get 18 hours of service, then you have elopement issues for the 6 hours that the person doesn't have services. That's a problem. That's dangerous. And so you can talk about that. You can talk about how often it happens, and you can talk about why it happens and what services you can get to prevent that from happening in the future. So really, you have a wide range to get witnesses to come in and testify, and anybody who can come in and say something positive and supportive for whatever the services that you're arguing that you need are going to be helpful to that hearing. One thing to note is that you do actually have an ability to request the judge to issue what's called a subpoena in order to compel somebody to come and testify. So that's for somebody who says, no, I don't want to come in and testify. I'm just not going to do that. But you feel like they're extremely important to making the determination of whether or not those services or supports are needed. You can write to the judge and ask for a subpoena for that person. But a word of caution to that, if somebody doesn't want to come and testify, you may want to consider that they might not give you the best testimony at that hearing. So be conscious of that the people who don't want to come and testify may not be helpful to your case and may be adversarial to you. So when using, or requesting a subpoena, be very, very considerate that you only want to bring information that's helpful to your case to these hearings, and the people who don't want to come might not be helpful to you for whatever reason. I think a really good tip to doing this is whenever you submit that additional information, be considerate that you're going to be over the phone or that the people might not be in the room for you. And whenever you ask people questions or whenever you're trying to make your argument, you may want to point to some of the documents that are in there. You may want to say, hey, supports coordinator, he has this goal that says he wants community inclusion, but he's been unable to leave the house for the last 20 days. You may want to point to that part in the IPOS if they don't know, because you have that information in the record. The best thing that you can do is just at the bottom right-hand corner of all those pages, just start doing page numbers. Start with 1, go up to 50 or 100 or however many pieces of paper you're going to have there, so that you're not caught at these hearings flipping through and trying to find the IPOS. You can say, why don't you look at page 30 right there, and I want to talk about some of the goals that are in the IPOS. And then the judge knows what page it's what page it's on, the CMH knows what page it's on, and so everybody's going to be on the same page, literally and figuratively, whenever you're trying to use these documents in the hearing, and you're going to have a much higher likelihood that the judge is going to be looking at the same thing that you're looking at, because you're going to be able to give that direction without having people trying to find that in just a jumble of pages. In addition to that, having a cover sheet on the front of all that evidence. So you're going to be able to identify, starting on page 1, there's this document, and starting on page 4, there's this document, and starting on page X, this document, so that the judge and the CMHs are going to know what the specific documents are, and they'll be able to quickly reference them if they want to go and look at the IPOS, because the CMH is talking about what the goals are or whatever may happen at the hearing. These are just ways to just keep it more organized. It makes the hearing go a lot more smooth, and it will help you in presenting your case, because you're going to be able to quickly reference all the material that you brought that's relevant towards winning your case. Just being considerate of that and thinking what's the best way and the smoothest way that I can reference everything that I think is relevant to this case. And I think that page numbers and a cover sheet are a really good way to do that.
So Kyle, what happens though if a person doesn't have a lot of their own documents? A lot of times folks don't always have copies of their individual plan of service or their person-centered plan, or things like, the case management or the supports coordination assessment or psychiatric evals. How would they go about getting that information so that they have something for their hearing?
Yeah, and there are only very limited instances where you cannot get that information from the community mental health or from the AAA. So really the best way to do that is just make a request, do a request in writing over email or via letter to your supports coordinator, and identify what documents you need. So if you need a most recent assessment, if you want the supports coordinator's notes for the last year on your periodic meetings with them, if you want a copy of your IPOS or your PCP because you don't have that, you can make that request, you can make it in writing, you should be entitled to get that information. And so if there's any information that either the community mental health has or your medical provider has, you need only go and ask for that information, because that's your information and you should be able to get it with very limited exceptions.
Okay, so in other words, to prepare for the hearing, you should have access to everything that you need so that you can defend yourself. The next question though is that you are talking about information that someone would provide to the CMH and to the judge prior to the hearing, but is there a responsibility on the part of the CMH to give the person information that they use to make the decision to change the service?
Yeah, that's a good question. So 7 days before the hearing, the CMH or the AAA or whoever the Medicaid waiver provider would be is required to submit what's called a hearing summary to the judge. And so the hearing summary should be all of the documents that they're relying on and coming to their determination, plus it will usually involve a brief written summary of how they came to the determination. So you should have a pretty good impression of the reasoning for this, because you've already received the notice and you've already gotten that local appeal decision. That should kind of enlighten you on what their rationale is, what their reason is. But this will probably be the most robust description of why they took the action. And this is going to be one of your first opportunities to see those specific documents or policies or portions of the Medicaid provider manual that they're relying on in coming to the determination. And so you get that 7 days before the hearing, and that's going to be the most information that you will get up, throughout this process, that's going to communicate and support that decision from that state entity.
It's really good information. And one thing that I want to make sure that I add is when Kyle was talking about the importance of making sure that what you need and want is in your person-centered plan, that is very, very important, because that person-centered plan is almost like a contract between you and the community mental health. So if there's a service that you want put in that plan and it's not there, then you need to make sure that it's noted somewhere in the plan, even if it's a service you requested and it's been denied. And some CMHs will allow supports coordinators or case managers to do that. So that's pretty important that you do that. The other side to that is if a service is taken away, having a lot of information about why that service is important in your plan at the outset is also very important as well. Individuals, they prepare, they go through this hearing. What happens after that?
Yeah, so you're prepped, you've been prepped from day one, you went through your IPOS meeting, you have a great plan of service that has awesome goals in it, you've made the request for the services that you need to reach those goals. The CMH doesn't agree with you, the AAA doesn't agree with you, so now you're at the stage where you're at a hearing. So you have a ton of information on what action the CMH has taken and why they took the action and what they're relying on to justify that. So now it's time to have the hearing. And whenever you go into the hearing, every single judge can be a little bit different, but generally speaking, the process will be, you'll go into the hearing. If it's over the telephone, obviously the judge can't see everybody, so the judge will ask, who's on the line right now? You'll identify yourself, tell them who you are, and then the judge will typically ask if we're waiting on anybody. Do you have any witnesses that are missing? Or is somebody here that's running late or anything like that? They'll want to make sure that everybody's present who needs to be there. Once they can confirm that everybody's present, the judge is going to do what's called going on the record. And so they'll let you know that we're going on the record. Every single judge has a little tape recorder that they have with them. Whenever he says going on the record, that means they're pressing play on that tape recorder, and everything that gets said during that hearing is going to be tape recorded. And if you wanted to get a transcript from that, you could have somebody type out word for word what was said on that hearing. It gets recorded. And whenever the judge begins, they will want to identify who is there. And so they will typically, say, okay, who's here? Can you state and spell your name? So, be prepared to identify yourself and spell your name for the record so that he has that. The judge will typically want to confirm that your mailing address is correct, because a decision will be written and mailed to you. So they usually want to double check that they have the right mailing address for you. Once they kind of identify who is there and everybody can make their appearances, and then the hearing is really ready to start. You are allowed to make an opening statement. Sometimes the judges will not do that unless you specifically ask for it, but you can make an opening statement if you want. And if you do make an opening statement, it's important to note that you don't have to make your whole case in the opening statement. That's the purpose of the hearing. And the best thing that you can do really in the opening statement is give the judge a heads up on what he's there, or he or she is there to do today. I think being conscious that these judges do a tremendous volume of cases, and there may be judges that have 10 or 20 hearings in that day, and to expect the judge to know everything about this case and have gone through everything is probably not an expectation that you should have. So at a minimum, doing an opening statement, just telling the judge what you're there for. Judge, we're here because the community living supports have been reduced from 50 hours a week down to 20 hours a week. We feel like that's inappropriate, and so we requested this hearing to contest this decision. Now the judge knows, okay, I'm here on a reduction of CLS hours, and he or she can tune their mind to what they're going to be hearing, because it's all going to be with regard to that issue. So at a minimum, using your opening statement just to let the judge know what they're there for can be beneficial, because you never want to expect that the judge will know everything whenever they come into the case. A lot of those judges are having these hearings and they're learning the information through the hearings. So giving them a heads up on what they're there to address at the beginning can be helpful in kind of framing the judge for what's going to be coming up. Another aspect of the hearing that will happen before you get into the argument stage is, we kind of covered that you'll get the hearing summary and you'll be presenting evidence. So everybody's submitted, these documents and this evidence over to the court, and both of the parties are going to have an opportunity to object to the entry of that evidence. Typically, you will do that on the front end of these hearings. So before going through the argument and, pointing your witnesses to whatever documents you have, you're just going to clear up whether or not that is going to be relevant and whether or not that's going to be admissible evidence. So whenever you get that hearing summary, if you think there's anything in there that's inappropriate, you're going to have an opportunity to object and explain why it's inappropriate to the judge. And you don't need to do that through any formal legal objection. If you think it's inappropriate, then that's your opportunity to say, I don't think this should be in here. Here's the reason why I don't think it should be in here. And I want to ask you to take it out of the record. So you're going to get that opportunity on the front end. They're going to get that opportunity with yours. You'll find that a lot of information is just going to get in because the rules of evidence are fairly lax in these hearings. So you'll have that opportunity, and if you think there's something in there shouldn't be, you can address that with the judge, usually at that early stage. Typically in a more formal court proceeding, you will introduce that evidence and lay the foundation, and it will be admitted one by one. But with these hearings, you just kind of do it all at the beginning usually, and that's your opportunity to try to get any information out, as well as if they object to your information, you can say why it's relevant and try to get it in. Those are kind of the preliminary things that will happen at the hearing. The judge will make sure everybody's there. They'll go on the record. You'll state your name and what your relationship is to the beneficiary. The CMH or the AAA will do the same. And then the state entity or the state agency, so the CMH or the AAA or the state, whoever the entity is that took the action, will typically go first in these hearings. So you'll get to hear their argument first, and you'll get to go second at the hearing. So for purposes of that beginning stage, the key is just pay attention, take notes. If they're saying something that's wrong, you get the opportunity to cross-examine them. So if they say something that's wrong, you can ask them about that. You can give them the information that shows them that what they're saying is incorrect because you've got that as a part of your documents that you submitted. So just paying attention, taking notes, seeing what, that should shape what your questions you're going to want to ask, because they may say something that's incorrect, or they may over-exaggerate something or under-exaggerate or under-report something. So just kind of, you know what your argument is, why you need these services. If they're saying something that's contrary to that argument, you get an opportunity to question them about that. That opportunity will be for any of the state's witnesses. So something to keep in mind whenever you're getting into that hearing is that the first thing you're going to do is listen to their argument. So just being prepared that I know that the first thing I'm going to do is not give my argument, but I'm going to listen to theirs, and I'm going to have an opportunity to ask their witnesses questions before I get to go. Then you go second, and then it's all up to you to make your case. You have all the evidence in already that's going to support your need for those services. You've got a great IPOS that has great goals. And so you're really just making this argument that this is a covered service. It is medically necessary for these reasons. And because it is a covered service and it's medically necessary, I should be entitled to get it because it's going to help me meet those goals. And so that's the general framework of what you're trying to communicate at these hearings. And that's kind of the process through my experience of how it will go kind of step by step and how you can best prepare for what's going to happen. And I do have a couple of tips on the hearing, but I think I'll just ask Mary Ann if I covered everything as far as the process is concerned, if she has anything to add on that.
No, the only thing I would ask is, can a supports coordinator or a case manager, are they allowed to testify on your behalf? If you're like, will the agency let them testify on your behalf or support you in a hearing?
Yeah, and a lot of times your supports coordinator can be your best witness. The supports coordinator is usually the person at the CMH or at the AAA who's the most familiar with your needs, the most familiar with your case. You're usually meeting with your supports coordinator at least once a month. So they know the person, they know the family, they know the needs, probably better than anybody else. Some supports coordinators are very, very supportive and great advocates for their beneficiaries, some not so much. But it's all up to you to request that they appear. I have found that if you ask for them to appear, that they will come voluntarily, almost universally. I have never run into an instance where a community mental health will prevent a supports coordinator from coming in. But don't assume that that supports coordinator is going to be a witness on the CMHs, because the CMH might not want this supports coordinator, especially if they're going to be supportive of what you're asking for that they disagree with. Never expect that all of the agency witnesses that you would want are going to be there. Make the request that they appear. And if you are prevented from having them, or if they refuse to appear, then you can circle back to the subpoena that we talked about and ask the judge to force them to be there, while you're taking into consideration that whenever I subpoena somebody who doesn't want to be there, they might not give me the best evidence, but that's how you can compel them to come if you have any issues with getting them to come. Generally, if you ask for a supports coordinator to come and be a witness, I found that they're more or less always voluntarily willing to come and testify, and they're certainly some of the best witnesses that you can call because they have so much information and history with the beneficiary and can speak to their needs usually better than, say, a supervisor or a utilization management person who may be the agency's main witness in the case.
Okay, thank you for that. No, I think you described the process really, really well. It's certainly a complicated process, but a necessary one. So what were some of the tips that you were talking about that you wanted to share?
Sure. So addressing medical necessity at the hearing. So remember that your services have to be sufficient in the amount, scope, and duration to achieve its purpose. And the purpose is achieving those goals that are in the individual plan of service and that person-centered plan document that you have. And so that's going to be where you're really going to want to focus your argument in on, I need this type of service and I need this much of it in order to achieve these goals. And you're going to, argue how much you need with support from your providers, with support from your family members, with support from your doctors, who are going to, hopefully have the same conclusion as you with regard to what your needs are and with regard to whatever you're in an argument currently over the CMH with what your needs are. And I did want to talk about just some common roadblocks that you'll typically encounter with making that argument. Probably the two most cited reasons for denying a service under medical necessity criteria, the PIHP the Community Mental Health or the Area Agency on Aging is allowed to deny it a service if there is a less or a more cost-effective service that's available. So the Medicaid program is unfortunately not able to give you the best thing all the time. It is a least cost program, and so if there is a cheaper service that can achieve the purpose, assist you in meeting the goal, then they're typically going to go, or actually they would argue they are required to go with that less costly alternative. So some examples of this, if I had my client who needed 24/7 service, for those of you who are familiar with the PERS button, so a personal emergency response, help, I've fallen and I can't get up. If I say, well, this person needs supervision over the nighttime, if there was an emergency that arose, then the CMH might want to say, well, we agree that there might be an emergency, there could be a fire, there could be a break-in, there could be something bad that could happen. But if they just press this button, it'll call 911, 911 can call, and that's going to be sufficient. It'll be cheaper than having staff in the house. And so it'll be up to you to, argue why that PERS is insufficient, why having the PERS wouldn't be available. Either they're unable to, press the button, they're unable to respond to the 911 call whenever it happens, understanding how the PERS work, and then, disputing why that PERS is going to be effective and having that person be safe in their house will be a really key thing that you'll want to focus in on at the hearing. And in addition to that, if you talk about like medical equipment, so say you want a shower chair and you want one that's made from steel because you use the shower chair, the material that you had, it broke, you got hurt whenever you were using it, and you want one with better material. And then the better material is going to make it more expensive. So the CMH is going to argue, well, you can just have a shower chair that's made of PVC pipe or some cheaper material because we're going to save $1,000. So it's important to address that issue as, okay, if I get the PVC shower chair, then I'm going to have it for 3 years and it costs $1,000. If I get the steel chair, I'm going to have it for 9 years and it only costs $2,000. So you're making the argument that this is in fact the cheaper product because it's going to last longer, and then you're going to break that cost out over time as opposed to just looking at the sticker price. So you'll want to be able to address those types of arguments because that is a very, very common way that services that you need can be denied or replaced with alternative services, more cost-effective type of service. And then the second one, and probably the main one, is utilization management reviews. And so sometimes they don't outwardly say it, but I think that most people usually think, okay, there's not enough money to provide this. They have a limited budget, and so you're going to get what you can get according to that budget. And so whether or not that's explicitly stated or implicitly stated, sometimes they just say, we have a limited pool of money. I have to serve everybody in this community. If I give you all of this, then I don't give this person, what they need. And so I'm in a catch-22 as the community mental health, just based off of whatever my funding is. And I'm gonna quote you something that's in the Medicaid Provider Manual. It's found on page 335, and it has to do with when a CMH or a prepaid inpatient health plan is going to be able to deny services. And this is what it says explicitly, and I think that this is the best counter argument that you can make to the argument that it just costs too much money. And what it says is that a PIHP, and so PIHP or community mental health, you can interchange those, but community mental health may not deny services based solely on preset limits of the cost, amount, scope, and duration of those services. And instead, the determination of needs for services shall be conducted on an individual basis. So if the only reason why you're not getting these services is because they are too expensive and they are covered services and they are medically necessary, that should not be the reason why you do not get those services. They need to come up with more than just that reason. It cannot solely be a budgetary issue to deny you those services, so long as you're meeting those other criteria. It's a covered service, it's medically necessary. They can't use preset cost limits in order to deny you that service. There is some pesky language in the B3 waiver that's frequently cited with regard to equitably dispersing the funds. But I think that provision in the Medicaid Provider Manual is very clear, and that's really your best argument that you can make whenever they're saying it just costs too much money or we don't have enough money to provide you with that service. And then just generally speaking, whenever you're having these hearings, bring some water. You're going to be talking. You see me drinking the whole time. You're not going to want to have a dry mouth whenever you're doing that. You might be nervous. Have some water so you can take a drink. Don't expect them to provide you with that. Don't interrupt other people. The judge will tell you when you can speak. They will tell the other party when they can speak. The judge is going to be in control of that. So if you hear testimony and you say, that's wrong, they're lying, whatever it is, let them lie, let them do whatever they're going to do. You get to cross-examine them. So that's your time whenever you get to go back, but you don't want to jump in. You don't want to, interrupt whenever somebody else is talking. You're going to want to let them just say whatever they're going to say, even though you may disagree with it. The time to address what you disagree with is going to be on your cross-examine. So whenever you get an opportunity to question that witness, which we already covered, you're going to have an opportunity to talk to every single witness that comes and gives testimony at that hearing. So just let them say their piece, and then address your issues with what they're saying whenever you get the opportunity to do it. It just has to go in that order, and you'll make the judge very happy to not just interrupt people and it's something that they don't like. Don't bring food if you can at all avoid it. If you need to take a break to go eat lunch or do something like that, ask for a break. It is not a good idea to try and eat and do one of these hearings, because you really need to have your focus on what the testimony is, what the judge is saying, what the witnesses are saying. And if you eat, it's just going to distract you from that. And with regard to testimony, so if you're going to be a witness as a family member, a friend, or a provider, or be questioned for whatever reason, knowing that it's okay to say, I don't know. You're not required to know the answer to everything. You're only required to answer questions that you know. So if you get asked a question and you do not know the answer, it is totally fine to say, I don't know. That is an acceptable answer whenever that is true. If you do know the answer, you can certainly answer the question. I would encourage you to just answer the question. That a lot of times whenever your nerves get to you and you're in these hearings, a lot of people have a tendency to kind of go on and on and on and get into things that are outside the question. You don't want to do that. You want to just, answer the question and then let them move on to the next question. And again, if the question, you don't know the answer to it, just say, I don't know. That's perfectly fine.
Thank you for that, Kyle. I think that's really helpful information.
And I think I just would note one more thing too, and this is just based off of my experience, that sometimes when you get to the hearing, you'll have a tendency to not communicate what the needs are in the real way, because whenever we're friends, we're family members of these people, we care about these people, we want them to be as independent as possible. And So we want to give them a lot of credit for that. We want to talk about all the positive things for them. And, there certainly is a place for that. But at the hearing, this is not the time to talk about, he's really, really great at this, she's really, really great at this. It's time to talk about the needs. And you have to be really frank and honest about what the needs are. Because if you are not honest about what the needs are, and if you report what the needs are, it will affect your ability to get the services. So just from my experience, I think that people tend to move more towards, I don't want to talk about this person in this way, but I do want to reiterate that it is extremely important to talk about those, to be frank, to be honest about what the needs are, because this is going to be your opportunity to get these services and supports. And, if you can't talk about it frankly and honestly, then you won't have a good outcome at that hearing.
Okay, thank you for that, Kyle. So because we want to leave a little bit of time for verbal questions, let's talk a bit about, so what happens after the hearing?
Sure. So after the hearing, usually the last thing the judge will say to you at the hearing is that they're going to issue a written decision. And so you won't get a decision on the record, and you'll get a written decision which will outline the law the judge is relying on. It will outline the decision, and it will tell you essentially whether or not the action is going to be upheld or reversed. And if you disagree with the decision of the judge in any way, it will provide you with instructions on how to appeal that decision. And so you can appeal these decisions. You can go into a circuit court in order to challenge that decision. That's probably a conversation for another time, because that process is much more complex than just doing the hearing.
Okay. So then they should be getting a decision like within 30 days, maybe, telling them whether they won or lost?
You should get a decision. It varies. I mean, you certainly should be getting a decision within 90 days. The hearing, depending on how complex the issue is, it can range anywhere from, 1 month to 3 months, somewhere within that range.
Okay.
And you can always call the court and ask them for an update, see where it's at, if there's any additional information on when you're going to get it.
Okay. All right. And then, so what happens then if you win? What if the judge says that the CMH or the Area Agency on Aging should not have taken away a service or changed it? How quickly do they have to respond to that?
Well, the judge will order the CMH to do something if you're going to win. So they're going to say the decision was wrong and now you have to do this. And so the CMH will have to submit an order certification over to MDHHS that says they complied with that order. I actually don't know the time frame that they have off the top of my head for that, but it is a relatively quick turnaround. And so you want to look at what the judge told them they have to do, and then follow up with the CMH to say, hey, they told me that I need to get reevaluated. When can we schedule the reevaluation? Or if the judge says that I got these services reinstated, where do I go to make sure that I'm getting these again if you didn't have continuing benefits? So whatever the judge says, you're more than welcome to follow up with your supports coordinator to see what they're doing, but they're certainly going to be required to comply with whatever the judge is ordering them to do.
Okay, that's great. So, well, Kyle, you've given us a lot of information, and I wanted to make sure we had a few minutes for questions, because we did have a question from somebody that I suggested that they, verbally ask you the question. But before we move to that, is there anything else that you would like to add that you feel like you've not talked about today?
The only thing that I would add is don't be scared of this process. This is not a process that requires an attorney. Everybody can do this, and don't let this process discourage you from trying to get the things that you need. If you need things to reach your goals, then this process is here to help you try to get those. So this shouldn't be something that people are scared to do. This is something that anybody can do, and we try to provide that technical assistance document in order to help you move through this process. But don't let it scare you. If you disagree with something, use this process. It's there for you.
Thank you for that. And I just want to reiterate, that one of the most important things that a person who's receiving services from either a CMH or from the Area Agency on Aging or waiver agent can do is learn how to be a really, really good self-advocate. It's really, really important for you to have those skills, and that's one of the reasons why the Mental Health Association is doing these webinars. It'll be turned into videos that you can refer back to, because this is such an important process. So we had a question from Mitchell. Mitchell, did you want to unmute yourself and ask your question?
Sure. Thank you, Marianne. I was curious, Kyle, if you've ever gone to a fair hearing where, as part of your preparation, you worked with CMH to establish a set of undisputed facts. You mentioned before entering all of these relevant documents, and I'm sure there's a lot of facts in them. You also mentioned the hearing summary, which is also a useful set of points from CMH about their argument or reasoning for the adverse decision, just as a general matter to streamline things, because the hearings seem to go pretty quick. Do you ever settle on undisputed facts with CMH?
I've done that before for more complex cases and ones that have a lot of history behind them. You know, obviously the main problem with doing that is agreeing on what the facts are. It's certainly something that you can do if the CMH would agree to do that. It's definitely helpful for the case if you can agree to really anything, facts included. So it's something that you would have available, but obviously would be, you know, conditioned on whether or not the CMH would agree with you on what the facts are. Oftentimes there's a disagreement on what the facts are, and so that's the reason that kind of necessitates the hearing. But you can certainly do that and submit that as part of your evidence for the hearing and use that however it benefits your case.
Great. Thank you, Kyle. I appreciate it. And just one other quick question. I was wondering if there's any closing statements. You had mentioned opening statements. I just didn't know if there was an opportunity at the end of the hearing to summarize your case and make it one last time.
Yes, that's actually a good point that I missed. You do have an opportunity for a closing statement, the same as an opening statement. You do not have to do a closing statement. But what you just mentioned, I think, is the best way to really handle it. Summarize what was presented, and then, you know, make your ask again. You're asking for a service, and recount just kind of briefly what the reasons are why you should be entitled to it.
Hi. My question is, I've been aware of a couple different situations with young adults who are younger than 26, so still have special education eligibility, and CMH will say, oh, we're not going to pay for a service, say during the hours that this person should be in school. And then the response from the individual and the family is, well, this, you know, school's not appropriate for XYZ reason, and we need the CMH service. Is that something that can be taken to a hearing, or can be the subject of a hearing?
Well, I guess you're going through the community mental health and requesting those services outside of the school or to be provided inside the school. Am I understanding that right?
No, to be provided, the situations I've been aware of are like outside of the school. So
okay, so like wraparound services or kind of supplemental services to whatever the school is offering through the IBE.
Yeah.
Yeah. So what you're going to want to do in a situation where you're not receiving something but you want to receive it is that you're going to want to look at whatever, you know, coverage they have. So if they're B3 or have waiver kids or wherever they may receive those services, make a written request to their supports coordinator for those specific benefits, and try to be as specific as possible to say, you know, he's in school for 8 hours and he comes home and he needs 4 hours of community living supports to do X, Y, and Z. And then if you make that request and do it in writing, just so you have it documented, you should be entitled to get a response, which may very well be a denial. And then once you get that denial, you'll be able to start moving through that process that we described today, as far as filing the local appeal and then going to the fair hearing. And, you know, ultimately that would be something that sounds like you're already doing, but you would encourage doing that through kind of the IPOS process to outline what those goals are for him whenever he gets out of school or she gets out of school, so that you have IPOS that's going to have specific goals that you can tailor those specific services that you're requesting towards those goals.
Okay, thank you.
Yeah, no problem. And always consider that you, if you go look at the Medicaid provider manual, there's an entire chapter on school services. So Medicaid can bill for certain services in school. So if there's additional needs in the school that aren't being addressed, you can look at that chapter to try and supplement what those kids are receiving in schools and have Medicaid cover it.
Okay, thank you.
Kyle, just one more question. Who can folks reach out to if they would like some help in preparing for a hearing.
There's a number of attorneys that can represent in these hearings. If you go to the State Bar's website and look for a disability rights attorney or an elder law attorney can typically do this. You can, you give some law firms a call and they can give you some referrals for this type of work. But, my agency takes calls. We have a call center that operates from about 9 to 4. And we generate technical assistance documents and can speak to people about CMH services as well and advise people on kind of what their legal rights are. My agency is always available to provide some technical assistance and short-term assistance for folks who are running into issues or have questions about this fair hearing process and about how to kind of increase your CMH services in the community.